sectional title or living in sectional title properties, as these definitions will help in the way that we go about our work. Our other panelist today is Adele Olivier. Adele is the branch manager of Trafalgar's Pretoria branch. This project Adele has championed and driven as the Pretoria branch team identified that training for sectional title caretakers would be significantly helpful for the caretakers we work with, that would allow us to talk the same language, to work more effectively together, to understand the important legal parameters, and to be able to, align accordingly. And we've built a training program very much around the questions that have been asked of us frequently from caretakers and trustees performing caretaker roles in the sectional title buildings that we manage. Just a quick prompt about next week's topic. Next week's topic is on HR, human resources, and it's a very important topic covering employment contracts. We're talking here about body corporate employees, typically the employees that you would be involved in managing as caretakers. So it involves payroll, leave management, performance management, the CCMA, setting up work programs, etc. And Trafalgar's national HR manager, Samira Ibrahim, and some other panelists will be involved in that. So I'm about to hand over to Karin, but once again, please don't hesitate to ask any questions. If you can't hear on your screen, please just check your volume. Please check that you have selected your computer microphone as well as your computer speakers. Hopefully, Karin, you can hear me. Can you give me a thumbs up if you can hear me? So hopefully my volume is working correctly. So if you connected correctly with your correct speaker selected, you should be able to hear. We can make the slides available for those that would like them. I will ask you to email me after the session, and we will also be saving a recorded version of this webinar onto YouTube, and we will be able to provide a YouTube clip to refer back to the content covered today. All right, so I'm going to hand over to Karin, and then we'll ask Karin to cover about sort of 8 to 10 slides. Then we'll take a pause, and any questions, group them, and we'll move forward with the hour and a half that we have in hand. So once again, welcome. Thanks very much for participating. And over to Karin to talk us through an introduction to the important concepts in sectional title and the sectional title legislation. Thank you, Karin.
Thanks, Andrew. Yes, hi, everybody. So basically, what we thought is that there's many concepts and many terminologies used in sectional title. So we picked a couple of them that I'm just going to run through with you, and obviously then we'll go to questions and answers as well. So the first one that we're looking at, and all of this is for a sectional title scheme only, and this comes from the Sectional Title Schemes Management Act, which governs sectional title schemes only. So the first concept that we're looking at is a scheme. So a sectional title development is called a scheme. That is the correct terminology to use. We also call it a complex sometimes, but the correct term is actually to call it a scheme. And a scheme is a building, or could be more than one building, that is divided into 2 or more sections. So we will talk about sections a bit later on. But the reality is, with a sectional title scheme, it can't be a sectional title scheme if there's not at least 2 sections. 2 or more, it's a sectional title scheme. If there's only 1 section, obviously, then it is not a sectional title scheme. It consists of sections as well as common property. So we'll talk about sections a bit later. We'll talk about common property a bit later, and the definition of each and the differentiation between the 2. And a scheme is developed over an earth or a stand, or it can be developed over a number of stands or urban. It doesn't have to be just 1 stand. It could be more than 1 stand. If it's a big scheme with a lot of units, then it could be that they've added a couple of earths together and built or developed the scheme on that. We get different types of schemes. We get purely residential schemes. Most of the complexes in South Africa is purely residential schemes. We also get schemes that are purely business, like a business park, for instance, or an office park. We get industrial schemes. We manage a couple of those where there's, for instance, the sections of factories. And then you get a combination. We manage a lot of complexes where there's a combination between residential and commercial, where you've got shops at the bottom and flats at the top floors. So it could be a combination, it could be a pure scheme. Each scheme has a name and an SS number, sectional scheme number. For example, SS 123 2016, but I'll get to what that means a bit later on. So yeah, Andrew, if you can page on to the next one. So basically the next item that I would like to cover, or the concept that I would like to cover, is a sectional plan versus a building plan. So each sectional title scheme has a sectional plan that is drawn up by a land surveyor or architect, and it has to be approved by the Surveyor General. The sectional plan, which I will show you an example just now, shows the layout of all the sections, and also it shows you a schedule of all the floor areas and the participation quotas. Now we'll get to participation quotas a bit later on and to why that is important, because in sectional title, unfortunately, that's the way it works. The bigger your unit, the bigger your participation quota, the bigger your say, but we'll get to that. But then the difference between a sectional plan and a building plan is that a building plan is drawn up by an architect and approved by council, and a building plan shows you the layout of the section. So it shows you the bedrooms, bathrooms, kitchens, etc. So if you can maybe just go onto the next page, Andrew. So there you see the building plan. It's a bit small, but it shows you the layout. It shows you where the kitchen is. It shows you where the bathroom is, living room, dining room, whatever rooms there are. This is all shown on a building plan. But if you go to the next slide, the sectional plan doesn't show any of that. It's just a block that shows you the outline of the section. And in this instance, it shows there's balcony and a courtyard as well. But it's very basic and simple, just showing the outline. The sectional title plan is essential in the management of a body corporate because it shows you where the sections are, what is a section, what is common property. And this is very important in the day-to-day management of the scheme. For instance, to determine the responsibility of maintenance of a certain area. Now we're going to have, in a couple of weeks' time, we're going to have a whole session on maintenance and how that works in a sectional title scheme. But there you will see that it's very important that we have the correct sectional plan in order to determine if it's a section, is it common property, is it exclusive use, is it what, and that will determine maintenance. The plans, as I said, also show the floor areas of each section and the participation quotas allocated to each section. And you can get a copy of the sectional title plan for your scheme. You can get from your portfolio manager, or if you want to, you can ask us for the details and you can get it directly from the Surveyor General. The Deeds Office used to keep sectional plans, but they don't keep them anymore. So that's basically sectional plan versus building plan. Then if we can go to the next slide, please.
You want to talk about the dotted line here, Karine, and there's CP denoting common property.
Yeah, there's a whole, we can go into a whole study of reading the plans. Luckily we have a course that we teach our portfolio managers. We have a whole module in there on reading the plans. And one of the things that we teach them is that when you see a dotted line, you need to take cognizance of the fact that it could be then common property. But in this case, that balcony is not common property. The dotted line is just a separation between the rest of the section and the balcony. But because there's a solid line around the whole area, including the balcony, that means in this case, the balcony is actually part of the section and it's not common property. It's the same with a courtyard. And then where it says CP and there's a dotted line again, that is basically where it shows you that this is common property. So I would say just looking at this picture, that is a staircase that we see there, and also a passageway that is shown as common property. But as I say, it's a whole study on its own on how to read these plans, but we can surely assist you with that.
It might be worth just saying while we're here, Karine, from a practical example point of view for everybody, because the balconies are part of the section, because they're drawn inside the solid lines of the floor area of this particular unit. And remember that the section number on the plans might be linked to a different door number at the complex. So there could well be a different door number attached to the section number. And at Trafalgar here, we have a schedule which matches door numbers to section numbers. A good example of that could be section 11 could be on the second floor, which might have door number 21 on it, but the sections are numbered differently in a sequence and don't typically readjust for different floors. So the floor number is why there could often be a different door number. But because this balcony is inside the section, the maintenance for this balcony now is an owner's responsibility, because owners are responsible to maintain their own sections, and they're required to ensure the contents in their own sections as well. So that's an important practical implication from this sectional plan. Also, if the owner wanted to do alterations in the balcony, there would be a different approach compared to if the balcony was common property or a different form of property, such as exclusive use area, which Karine will talk about just now. So those are a couple of the practical implications, and why understanding the designation of the different areas in a body corporate or a sectional title scheme is so important, because it affects how those areas are maintained, who pays for the maintenance, and how to go about making alterations if and when required. So hopefully that is fine. Just a quick question here. It's absolutely fine to participate by cell phone. If you've got a smartphone, you hopefully will see the images. Otherwise, hopefully you can hear the verbal commentary. And if you email an address that I'll give you at the end, we can certainly email the training slides across to you. All right, Karine, I'll move on to the next slide. Thank you.
Okay, so the next concept that we're looking at is a sectional title register. So basically, they call it a sectional title register, but it's actually just a file. So each scheme has a file at the deeds office where they keep all the documents regarding the scheme, from the registration of the scheme to the rules, previous rules before the new act, which we'll come to that. But it's basically a file that is kept at the deeds office for each scheme. Okay, the next one, please. Okay, so now we get to the concept of a section. So the concept of section is unique to sectional title. No other community schemes that we get have the units called sections. It's only in a sectional title scheme. And they are individually owned. Remember, I said that there should be at least two, so they should be individually owned. And they are clearly marked on the sectional plan, as we've just seen. And it's normally the house or the flat that the residents live in. But it is also possible for a garage, a storeroom, a parking area, or servants' quarters to also be shown as a section and individually owned by an owner. If you look at that little picture that I drew there, you will see that there's a line drawn in the middle. It's a bit small, but you'll see there's a line in the middle of that block. And that is basically the median line. Thanks, Andrew. So the median line runs in the middle of the floors, runs in the middle of the walls, and runs in the middle of the ceiling. So from the median line upwards is common property, and from the median line inwards is the section. So you'll basically see that is just a little one-unit building with one section that is basically showing you what is part of the section or what is part of common property. That is, as Andrew said previously, it's important to know what is part of the section and what is part of common property when it comes to the maintenance of the area. So if we look at the next slide.
And can I just say, for summary purposes, that the boundary line for the section is the middle of the floor, the middle of the boundary walls to the neighboring units if there are, and the middle of the ceiling. That's where the boundary line lies. If they're windows or doors, the middle of the window and the middle of the door is typically part of the boundary line as well. So everything inside the boundary line, which is the section, is the owner's responsibility to maintain. It's what they own as the section, plus the undivided share in the common property. And importantly, in the roof, you can see that the middle line of the roof is the boundary line. So the maintenance of the roof above that middle line is actually the building's responsibility, the body corporate's responsibility under the authority of the trustees. So I think those are very practical, important implications of the boundary line of the section. And remember, the section that we saw in the sectional plans was really just the floor area. We just saw the helicopter view or the bird's eye view of the floor area only. It didn't show the three-dimensional structure, but just remember, it's the middle of the ceiling, the walls going through the middle of the windows and the doors, as well as the boundary of what the owner owns directly and what is common property outside that for the body corporate scheme to maintain under the control of the trustees. Right, moving on, Karine, there we go.
Okay, yeah, just Andrew, just to add to add to that is basically that if you can just go back to that slide, please. If you look at that little block, so that's just a 1-unit little building. But if you imagine next to it another unit, then the median line that runs through that wall separating the 2 units will separate the 2 units. So from the one side, from the median to the left will be one section, and from the median to the left will be another section. And then there's no common property involved between sections. So that is also important in terms of maintenance, where you, for instance, have the top unit that there's a leak from the shower through to the bottom unit, where there's no common property involved, and the problem lies between the 2 units and between the 2 owners. But as I said, we have a whole session planned on maintenance where we will go into a lot of detail like that. So continuing with the section.
Karine, do you mind if I bring in some questions at this point?
Okay.
All right. Question about the geyser. What about the geyser above the ceiling in the roof cavity?
Okay. In terms of the Act, the Sectional Title Schemes Management Act, the geyser is always the responsibility of the owner. They don't use the word geyser in the Act. They talk about the hot water installation. So the Act specifically says that no matter where it is situated, even if it's situated on common property, even if sometimes we get a block of flats where there's say for instance 3 floors, and in the top floor in the roof there's 3 geysers that are servicing the bottom 3 units. So the geyser is far from the unit, but it still remains the responsibility of that section owner who that geyser serves. So the Act says doesn't matter where the geyser is, hot water installation, so that's the geyser as well as the hot water pipes, is always the responsibility of the owner.
And Karine, pipes in the walls, so utilities running through the walls, whether they're plumbing or electrics or anything else, gas, for example.
Yeah, there's a bit of a, I don't want to call it a fight, but there's a debate going about that out there. Some people, and I am one of them, who are of the opinion that Section 3(1)R of the Sectional Title Schemes Management Act specifically states that the body corporate is responsible for all pipes, wires, cables, and ducts. Doesn't matter where they're situated, doesn't matter who they serve. But the other half of the scheme, of attorneys and industry experts out there say no, that is not the right way to read the Act. The Act says that it depends on where the pipe is situated. If it's situated on common property, then it is the body corporate's responsible, and if it's situated inside the unit, then it's the owner's responsibility. But yeah, luckily, as I said, with the hot water pipe, it's easy because the hot water pipe will always be the responsibility of the owner.
I think for practical purposes, most buildings where they piping, etc., or electric, supporting other sections or units as well. So if the supply is not for that specific section only, but other units as well, typically the body corporate would maintain those and deal with any repairs as well. Karina, question, does the roof as common property also apply where the units are single story? So I would think yes. If it's a single story, the common property goes from the middle of the roof.
Middle of the ceiling, yeah.
Middle of the ceiling, and above that would be common property for the body corporate to maintain. Okay. A supporting column. So if there's a retaining wall inside a section, that wall, would it be common property or within the section? So a supporting column in a downstairs unit, for example.
Now, everything inside the section is part of the section.
Okay. Should the boundary and the common property be defined or clearly set out in the sectional plan?
Yes, the sectional plan shows you exactly what is a section. It doesn't always show everything that is common property. So sometimes we get gardens. We physically go to the complex and we see there's gardens and there's walls built. But if we look at the sectional plan, we don't see these gardens. But what the Act tells us, if it's not shown as a section on the plan, then it is common property. So if you see something in real life that is not shown on the plan, then it is common property.
Okay. Just a reminder, so the geysers that might be in the ceiling cavity or in plumbing ducts or anywhere at all, the maintenance of those geysers is the responsibility of the owner of the unit which that geyser supplies.
Yes.
The insurance policy for the body corporate would typically cover a burst geyser. So if the leaking geyser is related to a burst geyser, the insurance policy would normally cover that geyser repair, but there's normally an excess which the owner of that section would need to cover unless there's a second insurance policy which covers the excess. So Trafalgar has a traffic insurance policy which covers the excess. In that case, the owner would not pay the excess because it's insured, but normally the owner would have to pay the service provider direct the excess, and the balance would then be paid by the body corporate insurance policy. So hopefully that does answer the question on geysers. I think we've answered this one. If there's a burst pipe in the wall that feeds a basin or a bath, who will be responsible for that pipe repair? So I think, is it correct to say, Karine, if it's a burst pipe, the pipe repair and the resultant damage would be covered by the insurance policy. But if the pipe bursting is related to poor maintenance or rusting of that pipe or other related maintenance items, the insurers would potentially repudiate that claim, but they would still honor the resultant damage. So it really depends what the reason for the burst pipe is. But typically, if it is just a burst pipe without any signs of maintenance deficit or issues around maintenance, it would normally be covered then by the insurers. From a body corporate point of view, the owner would not be responsible for those repairs or the replacement of the resultant damages. You agree with that feedback, Karine?
Yes, sir.
Okay. Buildings with heat pumps on the top of the roof. So the heat pumps are typically body corporate equipment. They would be owned by the body corporate. The heat pumps would supply hot water to a number of units, potentially a block or the whole building, and the hot water circulates in a hot water ring main around the units in a chain-like fashion. So the full heat pump installation plus the hot water ring main would be body corporate equipment and responsibility to maintain. So hopefully that answers that question, Rudolph. Geysers are the owner's responsibility, but they are typically insured by the body corporate insurance policy, but there is normally an excess to repair a burst geyser, which would be charged to the owner, for which that geyser supplies hot water to their unit. So Drusilla, hopefully that does answer your question there. If you there's a question here about a new buyer who would like the evidence of the body corporate being insured. So typically you could ask for the insurance policy, Naledi, which would give you the insurance provisions for that body corporate. It gives you a policy schedule which outlines all the elements of the insurance cover. Also at the annual general meeting every year, the insurance policy schedule is presented at the annual general meeting, and that does give a breakdown of the insurance per section and for the body corporate and what is covered, which would confirm what the insurance cover is. But you could certainly ask the portfolio manager for a copy of the insurance policy, and Karine might refer later, all sectional title schemes need to have an insurance replacement survey every 3 years. So you could also ask for a copy of the insurance survey report, which would be the basis for the insurance cover and policy. Okay. Karine, who is responsible for a leaking balcony roof?
Okay, it depends. It depends on is there a balcony above? Is it just the top unit which has a roof over the balcony? Is the balcony part of the section? Is the balcony common property? Is the balcony an exclusive use area? So yeah, it's not just a simple answer. We will have to look at the plans, we will have to look at the rules, and we'll have to determine there is not just a quick answer on that.
Okay, there are a few questions like this, so let's come back to that when you cover exclusive use areas, Karina, and maybe we can take this example of how would we investigate, what do we need to know to decide who is responsible for these repairs and the related costs. Okay, so I think we'll move on with the slides. I have the remaining questions. We will come back to that, and potentially some of these will be answered by Karina's next comment. Okay,
yeah, just remember that this is just the start of this training session. So this is basically an introduction session where we're just going through the concepts and just explaining some of the concepts. So as I said, we have a whole session planned on maintenance where we're going to go in depth on maintenance issues and how to deal with that. So maybe we shouldn't get too complicated in this session because we are going to deal with it in the next session. But yeah, we'll try and answer as far as we can. So if you look at just finalizing the whole idea of a section, as I said, a section is measured by floor area. And as Andrew mentioned, the median line determining the split between a section and the common property, or section and another section, runs through the windows and doors. So a couple of years ago, it wasn't clear where windows and doors fall in the division, but now since 2010, it is clear that the median line runs through the door and through the window. So the inside of the window is section, and the outside of the window is common property, and the same with the door. And as Andrew said, the door number and the section number is not always the same, but we do keep record of those in our system as well. Okay, then we go on to common property. So the concept of common property is not unique to sectional title schemes. In homeowners associations, you also get common property. And as I said before, in terms of a sectional title scheme, everything that is not a section is common property. So it basically simply divides, you have buildings and buildings that are divided into sections and common property. If it's not a section, then by default it is common property. But then obviously you get different types of common property as well. So the next point just shows some examples where you can have, as I said, you can have a garage or a storeroom or a parking bay that is a section, but if they're not shown as sections, then they're common property. The driveways, the gardens, the communal areas, swimming pools, tennis courts, the outside of the walls, the foundations and the roof, all of that comprises common property. As I said, gardens, all of that. So the ownership of the common property is split in undivided shares between all owners of sections in the scheme. If you own a section, by default, you own an undivided share of the common property in the scheme as well. But in terms of this ownership, it has nothing, and the use of the common property has nothing to do with the size of your section. As I said, size of a section is important, but not when it comes to using the common property. So we cannot say that I have a bigger section, so only I can swim in the deep end of the pool, and you have a small section, so you can only sit on the steps. It doesn't practically work that way in sectional title. Use of the common property is equal to all owners. So if we go to the next slide, so basically we've talked about a section, we've talked about common property, and these two together, the section together with the undivided share of a common property, is what is called a unit. So that is the correct definition of a unit in a sectional title scheme, is a section together with the undivided share. You cannot sell your section without automatically selling the undivided share in the common property, and the undivided share in the common property cannot be sold without automatically selling the section. So basically what happens is that when a unit is sold, it gets transferred in the deeds office from one owner's name to another owner's name, and to the section together with the undivided share of the common property. If there's exclusive use rights on any part of the common property, which we'll look into a bit further later on, it must also be transferred to the new owner, or it must be ceded back to the body corporate. If it doesn't get transferred, to the new owner, then it automatically cedes back to the body corporate. It's not possible for you to have exclusive use rights over a portion of the common property without also being an owner of a section in the scheme. So the developer cannot sell all his units and keep a couple of exclusive use parking bays. It doesn't work that way. The minute he sells the last section, the parking base automatically cedes back to the body corporate. Okay, so then we look at the definition of an owner. So in terms of the Sectional Title Schemes Management Act that came into effect on the 7th of October 2016, there was a new type of owner added to the definition of an owner. It now also includes the holders of a lease for 99 years or longer. An owner can be a person, it can be more than one person, it can be a trust, it can be a company, but an owner is basically the registered entity or the entity in which the section is registered. The ownership of the section is registered. So between me and Andrew, we can together own a section, or we can have a trust that owns the section, or we can have a company. The minute that the section is transferred to another person or entity, then I am no longer the owner, I'm no longer reckoned as an owner, and the names of owners are recorded in the deeds office. An owner is automatically a member of the body corporate, and the body corporate is all owners. But we'll talk about the body corporate a little bit further on. But yeah, when you become a registered owner, you're automatically a member of the body corporate. So if we can just go to the next slide, please. Unless you want to add something there. No. Okay, bondholders. That is also a role player that we get in sectional title, is that some owners take out a mortgage bond over these sections, either by necessity or choice. The bondholder is normally a bank, but it can be any type of financial institution that enters into a bond agreement. So another term for a bond is a home loan. When you take out a home loan to buy a house, or you can later on, you can take out a bond if you want to do extensions to your house or something. And the bondholders' details are normally recorded on the insurance policy of the scheme. They have to, and that is when they're called registered bondholders, is when they notify the body corporate of their interest in a certain section. It is recorded on the insurance policy that they have an interest in that section, and we keep a record of that.
Right. Yes.
Going to go to the next one. Okay, so now something that we use a lot in sectional title, the participation quota, or what we just shortly call a PQ, is a very important part of sectional title legislation. And basically every single section in a scheme has a participation quota or PQ. It is a percentage. It is shown, and it's based on the floor area of your section, and it is basically shown as a percentage of the total of floor areas of all sections. So you take this floor area of one section divided by the total floor area of all sections, and that is how you get to the PQ. But we should never calculate PQs. The Act says that we have to work on the sectional plans list of PQs. If we see that is wrong, then we need to get the plans amended. But until the plans are amended, that is what we have to work on. I'll come to what is determined by the PQ just now. But basically, just that, yeah, the Sectional Titles Act stipulates that the PQ must be shown with 4 decimal places. But if it's an older scheme, you can see that sometimes they are only shown with 3 decimal places. That is not wrong, because your scheme was developed under the previous act and the old act, which is fine. But new schemes developed since 1986, the PQ are shown by 4 decimal places. And then the total of the PQs sometimes add up to 1, sometimes it adds up to 100. Neither is wrong, neither is right. They're both right. The total PQs of the section can either be 1 or be 100. It's shown as a percentage. Then if you can get to what the PQ determines, that is on the next slide. So the PQ determines 3 very big things. It determines the size of the undivided share in the common property. It determines the value of the vote of a section, and very importantly, the share of the levies. So the bigger your unit, the bigger your participation quota or PQ, and the higher your levy. But also, the bigger your unit, the bigger your PQ, the bigger the value of your vote when it comes to voting in value. It is possible for a body corporate to change this so that they don't work on the participation quotas, but that they rather work on nominated values. Example of this, many years ago, I managed a scheme in Pretoria where there were 9 units, and the units were all the same size except for one unit. One unit was a little bit bigger than the other units. So in terms of PQs, that one unit had a higher PQ and had to actually pay a higher levy. But all the owners, there were only 9 of them, they came together, they passed a special resolution to say that they will not work on PQs. They want everybody to be treated equally, even though that unit is a little bit bigger. So they allocated a schedule of nominated values, which is a value other than a PQ that is actually nominated to a section, and they allocated the same nominated value to each section so that they never have to worry that this one owner pays a little bit more or this one owner has a little bit of a bigger vote. So that is possible, but the Act says that where any owner is adversely affected by this, he must give, or him or her, they must give their written consent as well. The nominated values change the value of the vote and the share of the levies, but it does not change the size of the undivided share in the common property. So I'm sure there are some questions now.
Do we come to an example of what the PQ looks like, the schedule on the plan?
The next slide shows you an example of a PQ schedule in the plans. If you can maybe just make it a little bigger. So yeah, so that scheme there's 16 sections. So there's section 1 to 16. There's the floor areas. You can see that section 1 is the biggest one. So it has the last column basically shows you the participation quotas. So you can quickly see there, the bigger the unit, the bigger the participation quota, the smaller the unit, the smaller the participation quota. And then the next
just
slide.
to give you a bit of a break, Adele, do you want to just explain how those participation quotas would be used to decide who pays what levy?
Yeah.
So how does the levy value get calculated from these PQs?
Yeah, so thank you, Andrew. So from the participation quota, this is one of the sections that we will do training on as well. We use the participation quota, which is a percentage, and when we do the budget, with regards to the expenses, like I said, we'll do a module on the budgets later on. We will take this percentage and calculate the levy linked to that expense for your body corporate. So they will take all the, let's take for instance, the caretaker salary, the municipal accounts, all the expenses, maintenance, swimming pool, wages. They will add that together and they will use this percentage to calculate what the levy is that you pay. Correctly what Corinne said, you'll see here, and Corinne, I don't know this building, but you'll see that section 1 will obviously pay a higher levy as mentioned. And then it looks like from section 12 to 16, could be something like storerooms, but they definitely also sections. So even though we've got smaller units with storerooms, they will also pay a levy. So they will also have to contribute to the expenses of the body corporate. So that's in a nutshell, more or less, how it can calculate it. So it's linked to a budget, the size, and then the percentage of the expenses is the PQ is used to calculate the levy that's paid on a monthly basis.
Okay, good, thanks. So Corinne, there are older versions of the sectional plans and the PQ schedule table where instead of adding up to 100, it adds up to 1. So that would be the older format, but that would be completely fine as well, wouldn't it? It still just gives the pro rata value of a participation quota related to the floor area of that particular section.
Yeah, and as I said, Andrew, some older plans will also show three digits after the decimal point and not 4. But that's also not wrong. That was just in terms of the previous act.
Okay, so hopefully that answers your question there, Mike. So it would actually be normally 3 decimal places. So it would be, for example, 0.123, for example, and then all of those would add up to 1. You know, here you can see it's a percentage format adding up to 100, and you've got the 4 decimal points. Either way, it should add up to 1 or 100%, whichever format is chosen related to the timing of when the scheme was developed and built. Okay, so shall we move forward? Karine, we'll go on to the next.
Yeah, the next slide is just, if you can just maybe zoom out a little bit, this is just an example of a nominated value. So this complex decided to go on nominated values. So they actually made their own schedule and they allocated their own values or PQs to the different sections, whatever the reasons for that may be. I think in this instance, some of the sections were garages, so they wanted to allocate, not in terms of the size, but they want to allocate a different value to garage sections than to flat sections. So that is also sometimes a reason why they would go to nominated values. But yes, that basically concludes that.
So maybe just to emphasize, everyone can see here that these garages are actually sections. So like Karine said, garages, storerooms, staff rooms, those could all be sections, but it would be mapped out in the sectional title plan and in the PQ schedule. That's where you would see how they are defined. And that definition is very important because, again, it determines who owns the area, who's responsible for maintenance, and how the voting related to that area would work. So you can see here, garages are sections, and here you've got the notional participation quota is the other way of saying nominated values. So that's where it defines that it's based on a determined value rather than a floor area based value, and the garages plus the flats then would add up to 1 in this particular format. Okay. All right, next one, Karine. I'll zoom out.
Okay, so the next concept we're looking at is also not an easy one to always explain, but we'll try to go into as much detail as possible. So basically, we get the concept of exclusive use rights. This is unique to sectional title. You don't get exclusive use rights in any other type of scheme. And it's basically is rights that's given to certain owners to use certain areas of the common property. So they have the exclusive right to use it, and it stops other people from using that area. So it's possible to create exclusive use rights over a portion of the common property in terms of, for instance, a garden. It could be a garage, it could be a parking bay, it could be a balcony, a storeroom, servants' quarter. It could be any part of the common property where it is decided to give one or more owners the exclusive use rights to that area. Sometimes people think that I am on the 12th floor of a block of flats, my balcony, I'm the only one that has access to that balcony, so it must be an exclusive use area. Unfortunately not. It can only be determined in terms of the plans or the rules. So you can have your 22nd floor balcony that is actually common property, stupid as it sounds, but yeah, sectional title legislation says that the only way we can create exclusive use is either in terms of the plans or in terms of the rules. It has nothing to do with access to that area. So the fact that you have a garden with a wall around it and a gate that only you can enter into doesn't make that garden your exclusive use area. We have to check the plans, we have to check the rules to determine if it is actually, in fact, an exclusive use area. Exclusive use will always remain part of common property. So exclusive use is just a type of common property. It always remains common property, and you don't get ownership of that area. It still belongs to all owners. You just get the right of use of that area. So if we can go to the next slide.
Karine, there's a question here. Who decides what is exclusive use and what's not?
Okay, we'll get to that.
Okay, very good.
Okay, so basically there are 2 ways to create exclusive use areas, and this is determined as we will talk to now. So you can do it either on the plans or you can do it in the rules. So on the plans, the sectional plans has to be amended to include these areas. So it can either be done by the developer before the register is opened, before there are other owners involved, before the body corporate comes into existence. The developer can sit down and he can decide that I want these certain areas to be exclusive use areas, and I want to show them on the plans. I have my architect draw up the sectional plans to show these parking bays as exclusive use areas. Once the body corporate has been established and the trustees or some of the owners speak to the trustees and they say, we want to create exclusive use areas in terms of the plans, then there's a procedure that needs to be followed. You will have to get the plans amended, and to create exclusive use in terms of the plans, you would need a unanimous resolution passed by the owners. We'll talk a bit about the resolutions later on and how you get certain resolutions, but a unanimous resolution in very quick terms basically means that all owners relatively have to agree to it. So it is not just something that the trustees can decide. It is not something that one owner can decide. The owners collectively have to pass a unanimous resolution to decide that we are creating exclusive use areas in terms of the plans. Once it's created, that you want to refer back to it, you refer to the plans to see, is this garden an exclusive use area in terms of the plans or not? The other way to create exclusive use areas are in terms of the rules. So basically, if you want to create exclusive use areas in terms of the rules, it will depend which rules you're using. So if you do it in terms of the conduct rules, you would need a special resolution, which is easier to get than a unanimous resolution. But if you want to do it in terms of the management rules, you need to get a unanimous resolution again, which is very, very difficult to get. So in terms of the two types of exclusive use that you get, the first prize best type of exclusive use that you can get is in terms of the plans, because it's a registered real right that you can mortgage, you can sell, you can you can sell it, you can mortgage it, you can rent it out. So that's the first prize, but it's difficult to get. The second prize of exclusive use is in terms of the rules, but when they change the rules, they can easily take it away from you again. So in terms of that, it is important also then, if it's created in terms of the rules, that you stipulate in the rules who's responsible for maintenance of that area. And also, if it's, for instance, a garden, it's important to state in the rules what is included in that area. Is the garden wall included? Is the garden wall also part of the exclusive use area? Because when it comes to maintenance of that wall, we will need to know, is it part of the exclusive use? Is it not? If it's not, then it's common property, then the body corporate will be responsible for maintenance. Exclusive use areas in terms of the rules is not a real right in terms of the law. That's why I say it's second prize. It's not last prize, but it's not the best prize. But it cannot be sold, it cannot be bonded, it cannot be leased. If we go to the next.
Can I just maybe sort of paraphrase what you've said to give you a short break? But practically speaking, the easiest time for exclusive use areas to be defined is by the developer, because the developer will not need to get other owners to vote and agree and decide with them, which is obviously harder to achieve. And in many cases, the developer will set this up from the outset with the development and construction of the site, and then the registration of the supporting documentation, which will already be the sectional title plans that we talked about earlier. So that's the way it normally happens. But as Karine said, it can be done through resolutions, and it can be done then in terms of the areas could be defined and set up in the rules, but there are sort of resolutions which need to be passed with voting parameters to agree to do that. So that's a lot more difficult to achieve. It takes time, it takes explanation, and it takes buy-in from a fairly large number of other owners to agree that. Where would you look to see what a particular area is? You would start by looking at the sectional plans. You would look at the area concerned on the sectional plans, and you would try to see, is it within the solid lines, meaning that it would be part of a section, or would it be within dotted lines, and then defined as exclusive use areas. And Karina, I'm right in saying that there's normally a table of exclusive use areas in the sectional plans towards the end with the PQ schedule, where you can see what exclusive use areas have been defined for the building, and that would help you cross-reference and check that that particular area may be exclusive use. If it is exclusive use, then it's part of common property. It would typically be for the body corporate to maintain. Unless it's not in the plans, you would look in the rules, and there are two sets of rules applying to sectional title schemes. There's so-called management rules, and there's a second set of rules called conduct rules. So it is important for all caretakers to have copies of both of these sets of rules, which are applicable to your sectional title schemes. You would look in those rules, you would look to see if the particular area is defined as an exclusive use area. There should be a diagram showing the layout of the particular area. It needs to be detailed so that all the elements of it are shown and defined, and often the maintenance of that area is then also clarified in the rules. So you would need to check in both places to be sure, but it's very important that you have an understanding of how the exclusive use area is defined, what is the exclusive use area, and then who is responsible for the maintenance and maintenance costs of that particular area. So do you agree with that summary there, Karine?
Yes.
All right, thank you. Let's go on.
Yeah, so basically what Andrew just said is if it's in terms of the rules, then there must be a layout plan that indicate where it's situated, what the number is that is allocated to it, and the purpose for which it may be used. So on the sectional plan, you will see the same. The area will be shown with a dotted line, as Andrew said. There will be a number allocated to it, and the plan will tell you it's a garden, it's a yard, it's a courtyard, it's a balcony, whatever it could be. So if it's done in terms of the rules, then it's also important to have such a plan and a schedule. And it's also best not to link the exclusive use rights when you do it in terms of the rules. Don't link it to a specific owner. Don't link it to a specific person, because the moment that person is no longer an owner of a section in the scheme, you will have to change your rules. So it's better to link it to a specific section, to say that parking bay number P2 is linked to section number 2 and not linked to Karin Kutsia. Then in terms of maintenance, the body corporate is responsible for maintenance of exclusive use areas in terms of plans. But then the Act says that the body corporate must recover a contribution from the owners for this. We call it an exclusive use levy. So if it's exclusive use in terms of the plans, the body corporate must recover exclusive use levy, which must be used for the maintenance of the area. If it is an exclusive use in terms of the rules, then it depends on what the rules stipulate regarding maintenance. If the rules stipulate that the owner is responsible for maintenance, then the body corporate cannot recover an exclusive use levy, because an exclusive use levy is to be used for maintenance. And if the owner is already responsible for maintenance, then the body corporate doesn't need to have money for maintenance. But if the rule does not stipulate that the owner is responsible for maintenance of the area, then the body corporate is responsible for maintenance and must charge an exclusive use levy to cover that cost. There is no formula for calculating an exclusive use levy. It is sometimes determined by the size of the area. The Act says it must be determined and calculated by way of the maintenance costs. So if the maintenance cost will be different for a balcony than it is for a garden, for instance. The levies are, if you can go to the next slide, please, Andrew.
Shane, Karine, could I just cover these last three questions? The management rules, do those cover how trustees should behave, or do conduct rules refer more specifically to trustee conduct?
No, the management rules, conduct rules are more for the conduct of all owners. Functions and powers and duties of trustees are covered more in terms of the management rules.
Okay, that answers that, thanks. And then we've got a practical example here. This is about changing exclusive use areas. So the example is an owner has 2 parking bays as exclusive use areas. They don't want one of them. How can that be changed so the second additional parking bay can be reallocated?
Okay, again, it depends on what type of exclusive use area it is. If it's exclusive use in terms of the plans, then it's a real right and it's registered in his name at the deeds office. So then he can sell that parking bay because it's a registered real right, and then a transfer, like with a normal house or unit, a transfer takes place at the deeds office where it's transferred to the new owner's name. But if it's exclusive use in terms of the rules, and the rules state that parking bay 1 is allocated to section 1, but section 1 doesn't want that parking bay anymore, then you have to change the rule to reallocate it to another section. But you cannot sell a parking bay that is allocated in terms of the rules.
Okay, so it would be a special resolution to reallocate that parking bay to a
If it's in the
owner.
conduct rules, yes.
Yeah. And can somebody lease exclusive use area, Karine? So that second parking bay, could the owner lease it and collect a rental for the exclusive use area that they're not using?
Yeah, and only if it's an exclusive use in terms of the plans, then it's a registered real right and it can be leased.
Okay, but not if it's an exclusive use in terms of the conduct rules.
No.
Or the management rules.
Or the management.
Okay, hopefully we've answered that question. Thank you. All right, let's carry on. I'll move to the next slide. Okay, so normally levies are calculated by PQs or nominated values, as we see, but exclusive use areas don't necessarily have PQs. So as I said, the costs, the exclusive use levies or contribution must be calculated in terms of the cost of maintaining that area. And just to repeat what I've just said, created in terms of the plans, exclusive use areas can be sold, bought, donated, left in your will, mortgaged, let, because it's a registered real right. If it's in terms of the rules, it cannot be sold, cannot be let, cannot be mortgaged. It's not a registered real right. Okay, so in terms of, yeah, that's basically that. Okay, so I don't know if there's any other questions on exclusive use before we step away from that. Yeah, I'll give you the scenario. I was just typing an answer. So a caretaker asked their portfolio manager, an owner was querying their ownership of a garage, and they did not want to pay a garage levy. And there was dispute over that garage levy charge. How should that issue be resolved?
Okay, so what I would do is I would look at the plans to see what the status of that garage is. Is it a section? Then you don't have a choice, you have to pay a levy, because all sections have to pay levies. If it's an exclusive use area in terms of the plans, you don't have a choice, you have to pay an exclusive use levy for that. Unless you don't want the exclusive use right, then we can transfer it cede it back to the body corporate or transfer it to another owner. We would also need to check the rules to see if it's maybe exclusive use in terms of the rules. And as I said, if it's exclusive use in terms of the rules and the owner is responsible for maintenance, then you cannot be charged a levy. But if it is in exclusive use in terms of the rules and the rules stipulate that the owner, or doesn't stipulate that the owner is responsible for maintenance, then you have to be charged a levy. That levy is used for the maintenance of that area. So either you pay the levy and the body corporate maintain, or you don't pay the levy and you maintain. So that, I don't know if that answers the question.
And also, I suppose if you don't want the area concerned, you either sell it if it's a registered real right, the exclusive use is on the plans, or you propose to the trustees to reallocate the parking in the rules and give somebody else the benefit if you're not wanting the benefit of that area with the cost, and then the rules would need to be updated by a special resolution. So those would be the sort of formal means to go about resolving that particular difficulty. All right, Karine, next up.
Okay, so next we look at the different role players that we get in a sectional title scheme. So obviously it starts with the developer, then the body corporate comes into establishment. We'll talk about that just now. Body corporate, remember, that's all the owners, all the members, so we'll talk about that. Then comes the trustees and then the managing agent. So if we can go to the next slide and look at the first person that comes into play is the developer. So the developer is the person who's the registered owner of the land. It could have buildings, it could be without buildings, and this person is the one who decides to subdivide these buildings into 2 or more sections. So it can either be existing block of flats where I am the sole owner of that block of flats, and I decide I want to make this sectional title scheme. I want to start selling off the sections, open a sectional title register, and make it a sectional title scheme. Then I will be the developer, but also the developer is somebody who physically develops a scheme, who basically builds a scheme, builds the units. Obviously, he can have subcontractors, all of that. But in terms of the sectional title legislation, the developer is the first owner, if you can look at it that way. So next come the body corporate. So basically, every single registered owner of a section in the scheme forms part of the body corporate. Some people incorrectly refer to the trustees as the body corporate, or they even refer to us as managing agents as the body corporate. That is not correct. The body corporate is every single owner of a section in that scheme. The body corporate is the governing body of the scheme. In Afrikaans, just to point out there, some people use the word beheerliggaam. That is not the correct term. The correct term to use is regspersoon. That is what a body corporate is. And it's not possible for you to apply for membership or resign from the body corporate. It is not something that you have to sign for. The minute you become the registered owner of a section in the scheme, you are automatically a member of the body corporate. And the minute that section is sold and transferred to the next person, you're automatically no longer a member. So you don't have to sign up or accept this or apply for membership or anything like that. It's an automatic thing. The body corporate comes into existence on the date of the transfer of the very first section from the developer to another person. So the minute there's two people who are owners of sections, then the body corporate comes into existence, and there's also a date allocated to that, and you get from the deeds office a certificate of establishment that shows the date that the body corporate came into existence. The developer ceases to be a member of the body corporate the minute the last unit that was in his name gets transferred to another owner.
Perhaps just some practical applications of this. So the body corporate is actually a legal entity. So the body corporate can be sued legally. The body corporate has a domicile address where legal notices can be delivered. The body corporate has to register for tax and tax returns with SARS. It needs a public officer to represent it with SARS and for SARS queries to be escalated. So it's important to realize that this is a legal entity of which all the owners are members. We often get asked by owners, they don't want to be part of the body corporate, they're tired of the body corporate, they often have a dispute with the body corporate. So as Karine says, that is not possible unless they sell their unit or units in the body corporate, and when that unit transfers out of their name, then by default they exit the body corporate. That is the only way to exit the body corporate, based on ownership of the section in that body corporate. So that would be an answer to a common question that we typically get.
Okay, so if we go to the next slide, so basically each body corporate has a name that is normally assigned to it by the developer, and a sectional scheme number or SS number. So it is possible to have different schemes with the same name, but it is not possible to have different schemes at one deeds office with the same SS number. What we did find is that you can have schemes registered at different deeds offices with the same SS number. So what this SS number thing, what it means, it is a number like a company registration number that is allocated to each body corporate. It looks like the example that Andrew is showing there. So in that example, SS stands for sectional scheme. 123 means it was the 123rd scheme registered at that specific deeds office, and the 1998 is the year in which it was registered. So it was the 123rd scheme registered in the year 1998 at that specific deeds office. So it is possible to get a the same complex or two different complexes with the same name, but if they registered at the same deeds office, they will have different SS numbers. if they are registered at different deeds offices, they could have the same name as well as SS number, but then the distinction is that it's a different deeds office that they're registered for. The body corporate enforces rules, controls, administers, manages the common property, is bound by the Act and the scheme's rules, and the functions and powers assigned to the body corporate is performed by the trustees. So that's basically the next concept that we're looking at, is trustees.
Karine, do you mind if I just take you back to a very good question here for the developer? Is the developer, do they still own the land when the last sectional title unit is sold and transferred?
No, the minute the body corporate comes into establishment, or the body corporate is established, the minute there's more than one owner, then all the land becomes common property belonging to the body corporate. So it's no longer owned by a developer or a person, it is owned in undivided shares by the members of the body corporate. So the minute the developer sells his last section, he's no longer a member of the body corporate, so he doesn't have an undivided share in the common property anymore. So he doesn't own any land anymore.
Karine, can I just come in there? Sorry, Andrew, but what
Please.
if they register Section 25 right over that piece of land on the body corporate?
Yeah, so basically what Adela is referring to is where the developer has a huge piece of land and he comes and he builds a couple of sections on that land, but he wants to reserve a right because it's a big piece of land. He actually can build more sections, but at the moment he doesn't want to do that. He wants to come back later to build those other sections. Then he can reserve what they call a Section 25 right of extension. So it's basically in terms of Section 25 of the Sectional Titles Act that he reserves a right for himself to come back later on to build more sections. So that is what we call building in phases. So he builds phase 1 with 10 sections, but he's got a reserve right to come back in a year or 2 years or whatever the timeline may be, but he has to reserve that right for a specific period. Normally they reserve it for say 10 years or so, but in that 10 years he can then come back and build phase 2 and phase 3 and however many phases, as long as there is space obviously for those sections. But then he is still not the owner of the land. He just has a right registered to come back and build more sections.
Sorry, Karine. Sorry, Andrew. Just a last question. So the maintenance of that land, that vacant piece of land, that will remain with the body corporate, even
yes,
though
because it's common property. It's the responsibility of the body corporate. But what the Act also says is that if the developer has such a right, such a Section 25 right reserved, then he must also make a contribution. It's not a normal levy, as in you would pay a levy for a section, but he must pay that contribution still to the body corporate, and that can be used towards the maintenance of that portion of the land.
Shall I go on?
Yes, please. Okay, so now we get to the trustees. So the trustees are basically a committee, if you want to call them that. They are not the body corporate. As I said, the body corporate is all owners. So it's a couple of people that are elected by the owners. They can't elect themselves. The owners must elect them. At a general meeting, they are elected as trustees. They are sometimes incorrectly referred to as a board of trustees. This is not correct because they're not a board. It's not a company. The scheme is not governed by the Companies Act. It is just, if you want to call it a committee of the CSOS Act, this Community Schemes Ombud Service Act, actually refers to them as scheme executives as well. It's basically a committee of people that is responsible for the day-to-day running of the complex. So in terms of the Act, there are certain functions and powers of the body corporate, and the Act stipulates that this must be exercised by the trustees, subject to the Act, the rules, and any directions or restrictions from the owners. So at a general meeting, the owners can actually tell the trustees what they can or cannot do over and above what the Act says they can and cannot do. But the trustees are not the be-all and end-all. They don't have all the power. They just have the power that is allocated to them in terms of the Act. There are many instances in the Act where they have to refer back to the owners, where they have to get permission from the owners to do certain things. So that's just a quick summary of trustees.
Maybe just worth saying, you do not need to be an owner to be a trustee. So actually you can get tenants being trustees, you get professional trustees that don't live in a scheme, you can even get non-residents being trustees. So that is not a requirement to be an owner.
Yes, Andrew, and on that, the previous act said that as long as the majority of the trustees are owners or spouses of owners, that is no longer the case. It is now possible to have a whole set of trustees that are all non-residents or tenants. So yes, you don't have to be an owner. The majority doesn't have to be owners. Anybody can be a trustee. Okay, when we look at the next role player, that is us, the managing agents. So basically, it is time consuming to manage and administer a scheme. There's a lot of things involved. There's a lot of knowledge involved to be able to manage it properly. So therefore, the body corporate or the trustees can decide to appoint a managing agent. It is not compulsory to appoint a managing agent, but it is definitely preferable to do so because a managing agent has more knowledge and experience than any trustee can ever have. We manage a number of complexes. We work countrywide, so we deal with a lot of different instances, so we have way more experience than even a trustee who's been a trustee for 10 years. We will have more knowledge and experience in that regard. A lot of complexes, especially small ones, opt for self-management. That is a possibility. It can be done. There's, as I said, no requirement that you must have a managing agent. But the problem is that mostly then what they do is they get somebody who's got an accounting background to do the job. So the finances are fine and in order, and the levy statements go out and is reconciled perfectly. But the legislation, the sectional title aspects are largely ignored. So definitely all schemes will benefit from appointing a managing agent. And if you look at the next slide, that basically sums up what we are responsible. We have a management agreement with the complex that determines our responsibilities. And that is basically on the next two slides, that's a list in terms of our responsibilities of what we do and what we assist the complex with. So I'm not going to go through all of that, but basically you will see that we open and operate bank accounts, we assist the trustees with insurance valuations every 3 years, collect levies, pay accounts, arrange meetings, assist the trustees with procedural requirements for meetings, keep the records of the body corporate, all of that. In terms of the next slide, you'll see that our duties continue. We have secretarial things. We dispatch circulars on instruction from the trustees. In terms of accounting, we assist the trustees with drafting of budgets. We give reports monthly to the trustees with regards to performance. In terms of the budget, we keep the financial records, assist the trustees with the annual audit. We can, as Andrew said earlier, be appointed as public officer to deal with tax matters. And then in terms of CSOS, the Community Schemes Ombuds Service, we collect the CSOS levies from the owners, we pay them over to CSOS, we submit annual returns to CSOS, and we can assist the trustees with conciliation and adjudication matters. So just as a quick summary of a managing agent cannot make decisions on their own. We are just advisors to the trustees who can make the decisions, or sometimes have to refer to the owners to make the decisions. So we work for the trustees, we work for the owners. We are not the boss. We cannot make the decisions, as I said. That's basically, so yeah, I don't know, I'm sure there's some questions now.
Yes, so I'm going to ask these to Adele, so you can have a short break, Karine. So Adele, if you want to be a trustee, do we need to look at your levy history if you are in arrears or not?
No, you don't. It used to be a problem in the previous act, Karine, you can confirm, but now the only problem, no, so for a trustee you don't have, it's just attendance that's been, or voting if you do have a default judgment against your name, but not for a trustee, correct, Karine?
If there's a judgment or a court order against you for arrear levies or contravening the rules, then you cannot be a trustee.
Trustees as well. Okay, thank you for that. Yes.
Yeah. All right, Karine, can you make a few comments on the fiduciary duties of trustees and the related risks? Is it similar to a company board director?
No, it's not similar to a company board director. It's way more difficult to be a director, and there's a lot of more hoops that you have to jump over to be a director. In terms of a trustee, summarize the fiduciary duty is that as a trustee, you always have to act in the best interest of the body corporate, not your own interest, not the interest of the other trustees. You always have to act in the best interest of the body corporate in everything that you do, in all the decisions that you make. So that is basically a summary of the fiduciary duty. So you cannot make a decision where you will benefit to the detriment of the body corporate or to the detriment of other owners. If there is a decision made at a trustee meeting with regards to, for instance, I have a garden service and we are looking in the complex for a new garden service, and I want to also quote on that. I cannot do that. I cannot be part of the decision-making process because I have the interest in the garden service. And it is also not possible for me in the end, if appointed, to be both. I cannot be a service provider to the body corporate as well as be a trustee without permission from all the owners.
All right, so another way of saying that is the trustees are typically accountable for the governance of a body corporate. So they would need to make sure that the body corporate is legally compliant with things such as registering for tax, submitting tax returns, having the annual general meeting every year within 4 months of the financial year end, making sure the building is insured, doing the insurance replacement surveys every 3 years, making sure that the body corporate budget is agreed so that the levies collected cover the body corporate expenses to continue service delivery at the building. So those are all examples of the governance expectations of a body corporate so that the owner's requirements are met, services are continued, and the trustees would oversee that and make sure that the necessary decisions are taken, the necessary measures taken to achieve that. The risks are that those are not achieved or that the incorrect decisions are taken, and there could be some exposure in that regard, but that would be the reason the trustees would be supported by a managing agent who has the systems, the experience, and the portfolio manager teams to advise them and support them and guide them to achieve the necessary outcomes. We did say you do not need to be an owner, you do not need to be a resident to be a trustee, so it is possible that there are trustees and even a majority of trustees that don't live on site, and that can create operational issues in terms of response times or being aware of what the challenges at a complex are. And Karine will talk about the executive managing agent next as a potential option to address that challenge. We did say earlier that the body corporate is the collective of all owners. So all owners of all sections in a scheme are members of the body corporate. The trustees are elected individuals at the AGM who are then responsible for the operational management or governance or decision making on behalf of that body corporate. And once again, they do not have to be owners. Some of them are generally owners, and generally they are not paid for their services, which they offer after hours and typically free of charge. So I think that covers that. The managing agent does deal with PAYE and payroll, so that is part of the standard services. Karine, can supervisors and caretakers be trustees?
Andrew, only if that person is also an owner of a section in the scheme. So you cannot be a supervisor as well as a trustee unless you are also an owner of a section in the scheme.
Okay, and can a trustee be fired?
Yes, absolutely. There's just a procedure that has to be followed. So if you want to remove one of the trustees, you have to call a meeting, and it must be stipulated on the agenda of the meeting that the purpose of this meeting is to remove Karine Kutsia as a trustee. It must be stipulated on the agenda, and then they cannot be removed by the other trustees. They have to be removed at the general meeting by the owners.
Okay, and just once again, there's a question about should a trustee step down if they fall into arrears with their levies? And I think the answer of that is only if there's a judgment against them for their arrear levies. They would not need to step down if they are only in arrears. although it would be a moral issue which should be discussed, but it would not be a necessity for them to step down. All right, Corinne, let's go on. We kind of running out of time a bit, so we'll move through the next slides quite quickly if we could.
Okay, so the next concept is an executive managing agent. So we get complexes where nobody wants to be a trustee for whatever the reason may be. So then it is possible for the body corporate by special resolution to appoint an executive managing agent. This is different than a normal managing agent, and it also mustn't be confused with an administrator. An executive managing agent takes over the functions and powers of the trustees. So you won't have trustees, you will just have this one person who functions as the trustees. And with an administrator, that is another concept where they take over the functions and powers of the body corporate as a whole. But it is possible, if nobody wants to be a trustee, it is possible to appoint an executive managing agent, and we also provide this service where we can be the executive managing agent where you don't have to have trustees.
All right, Adele, can you just quickly answer what is the process for changing a managing agent?
So you need to, first of all, have a look at your management agreement with the managing agent. Normally, with regards, and Corinne can confirm when it came into place, you need a special resolution to change the managing agent, or you need to give them notice in terms of the provision in the contract. Corinne, you can confirm that for me.
Yeah, just to add to that, you have to look at your management agreement to see if it has expired or not. So expired means after 3 years. So the Act says that a management agreement cannot endure for more than 3 years. So after the 3 years, it automatically expires. Doesn't matter what the management agreement says. That doesn't mean that you have to appoint a new managing agent every 3 years. It just means that you have to sign a new management agreement with your managing agent every 3 years. So once you're in the 3-year period, as Adele said, you have to pass a special resolution and give that managing agent 2 months notice if you want to terminate their service. Once the contract has expired, the trustees or the owners by ordinary resolution can give the managing agent notice to terminate their services.
Okay, thank you. Let's carry on, Corinne. So next slide.
Okay, so next slide, we're looking at rules. So as we said earlier, there's basically 2 sets of rules in a complex. There's the management rules as well as the conduct rules. The management rules are contained in Annexure 9, was contained in Annexure 9 of the previous Act. It is now Annexure 1 of the Sectional Title Schemes Management Act. And the prescribed conduct rules are in Annexure 2 of the Sectional Title Schemes Management Act. So just shortly, it is possible for the developer, before establishing the body corporate, to amend the rules, to customize rules for the complex. But once the body corporate has been established, you need a resolution from the owners. To change management rules, you need a unanimous resolution, and to change conduct rules, you need a special resolution. Special resolution, easier to get than a unanimous resolution. Special resolution you can do at a meeting where you need a normal quorum of the owners to be present, and then 75% of the owners present in number and value must vote in favor of the rules to be passed. If you do the conduct rules, propose it on a round robin basis, then 75% of all owners need to approve the rules. Management rules is a unanimous resolution. So to get a unanimous resolution at a meeting, you need a quorum of at least 80% of the owners to attend the meeting, which is very difficult, obviously, to get. But if you do get it, then everybody present and voting must vote in favor. If one person vote against those rules, then they're not passed. And if you do a management rules on a round robin basis, then you need every single owner to approve those rules. Just the difference between the rules: management rules govern the management of the scheme, things like the duties of the trustees, things like that. And the conduct rules govern the behavior of owners, tenants, residents, employees, and guests of owners. The rules must always be reasonable, and it cannot be in contravention of the Act. It must apply equally to all owners, and it binds owners, occupiers, and cannot be changed. we are going to have a session completely on rules and the enforcement of rules, where we're going to go into, because I know you'll have a lot of questions with regards to enforcement of rules, but we are having a session later in a couple of weeks where we are going to talk about rules and the enforcement of rules.
Okay, thank you.
Okay, so then we get a bit to financial management. So just looking at budget, admin fund, reserve fund. So the administrative fund of a scheme is basically what is used for the day-to-day expenses of the body corporate. So with the previous act, we only had an administrative fund. Money came in, money went out. Income in terms of levies, expenses in terms of what was paid for the body corporate. But with the new act, with the Sectional Title Schemes Management Act that came into effect from the 7th of October 2016, there's a new concept called a reserve fund. Every single body corporate must have a reserve fund, and the reserve fund is used to fund long-term maintenance, planned maintenance. So in order to plan your maintenance, what is also prescribed is a 10-year maintenance, repair and replacement plan, which every complex must have. This plan gets approved every year at the annual general meeting and determines what needs to contribute to this reserve fund. So basically what that means is that all owners will have to then pay 2 levies for each section that they own, the admin fund levy as well as the reserve fund levy. And these funds both have their own budget that is approved at a general meeting. So to compile a budget, if we can go to the next slide, please, Andrew. Okay, so to compile a budget, you need to look at the expenses of the body corporate. So you need to make a list of all the monthly expenses. We get recurring payments, which is service providers where the body corporate has a contract, which, for instance, the garden service, the security service, things like that. We call that recurring expenses. So we need to make a list of that so that we can budget properly for that. And then also sometimes with a contract payment or a recurring payment, you see that the price gets escalated once a year. So you need to budget for the first 4 months, this will be the price, and for the next 6 months, that will be the price, whatever the case may be. And then we get what we call ad hoc expenses. So basically, things that are paid that are not part of contract payments. Light bulbs need to be changed. Now I'm blank. Now I can't think of any ad hoc expenses. But it's basically just day-to-day expenses that are not part of contract payments. And based on this list of expenses, you will then need to determine what the income will be to cover these expenses. So I have the example of a budget. I don't know if we have time to go into that.
Let's come back to this time, Karine, that we actually are out of time. So I think let's come back to it.
Okay. So in terms of income for the body corporate, the biggest portion of income that or source of income that the body corporate gets is levies. So levies are raised on sections, as we said before, and it is the levies payable as is determined by the trustees after the AGM. So at the AGM, a budget is approved. The budget says we need 100,000 Rand to cover our expenses for the year, and the trustees then afterwards determine how that 100,000 Rand is recovered from the owners. It could be recovered monthly, it could be recovered annually, it could be weekly, daily, whatever the trustees decide, but the standard practice is that levies are paid monthly. It is also, the trustees must pass this resolution to say that it is paid monthly, and the Act also doesn't say that levies are payable at a certain day of the month. So the trustee passed what we call a levy resolution to determine when the levies are payable and how it's payable. Levies, as we said before, are calculated in terms of participation quotas or nominated values, whatever the body corporate may work on. And it is also possible for the trustees to raise special levies where there's an unforeseen expense, unforeseen emergency maintenance that come up. It is possible for the trustees to raise a special levy over and above the normal levy. And special levies are also calculated in terms of participation quotas or nominated values. Okay, then we get to the CSOS levies. So also in October 2016, there was another new act that came into force. That was this Community Schemes Ombud Service Act. And this act places an obligation on all units in community schemes that include sectional title schemes to pay a CSOS levy over to CSOS. So the levy is calculated on the monthly admin levies of a section, and the first 500 Rand is exempt. So there is a formula. You take your monthly admin levy, you deduct 500 from it, then you work out what 2% of that amount is, and that will be your monthly CSOS levy, to a maximum of 40 Rand per section per month. It is important to note that CSOS levies are payable on all sections. So if you own a flat that is a section, but you also own a garage that is a section, you will pay 2 levies because it's 2 sections. You cannot add them together and then calculate the levy because the first 500 Rand of a section is exempt. So if your garage levy is less than 500 Rand, then you won't pay a CSOS levy on the garage, but your flat could be more than 500 Rand, so then you will pay a CSOS levy on the flat. So yeah, it's just important that we cannot add them together. CSOS levies are only calculated on the monthly admin fund levy, not on reserve fund levies, not on exclusive use areas, and not on special levies.
Good.
Okay, then we get to the big, there's a number of meetings held in a body corporate in the sense of operation of a body corporate, but the biggest one is the annual general meeting, what we normally just call the AGM. So the AGM is held annually. It has to be held within 4 months after the financial year end of the body corporate. And in order to have the AGM, the books must be audited. So we assist the trustees with getting the books audited. We assist the trustees with getting this meeting arranged. We send out the notices of the meeting. There's a certain way they must be sent out, certain time frames in which they must be sent out, and the agenda is prescribed by the Act. For the meeting to be validly convened, there must be a quorum of owners present. The quorum is determined by the number of sections in the scheme. So it could either be 1/3 of all the owners that must be present, or it could be 2/3 of all the owners that must be present. And if you cannot attend the meeting, then you can appoint a proxy to attend on your behalf. But with the new Act, there's a new rule that says that you can only allocate 2 proxies per member. So what that basically means is if Andrew gives me his proxy and Adele gives me the proxy as well, then somebody else cannot also give me a proxy because I can only represent 2 people. A proxy doesn't have to be a member, but it cannot be the managing agent, it cannot be an employee of the managing agent, and it also cannot be an employee of the body corporate. So as a caretaker, you cannot attend the meeting with a proxy from somebody else. Okay, and I think then it's the last slide is the 10-year maintenance plan. So as I said, this is a new concept in terms of the Act. From 7 October 2016, all bodies corporate are obliged to have a 10-year maintenance, repair, and replacement plan. So the object of this is proper maintenance assessments and planning for the next 10 years. So there is no prescribed format that this must have. There is nothing that says it must be done by a professional company, but obviously it is advisable to have a professional company do it if you can afford it. But basically it is a simple spreadsheet with 10 columns, one for each year, and it basically shows that what are we planning to do in terms of maintenance for the next 10 years. In year 1, we plan to redo the paving. In year 2, we plan to redo the piping. In year 3, we plan to paint the complex. In year 4, we plan to do something else. So basically, it's a plan for the next 10 years, and it's a rolling plan. So every year, the first year falls away, and another year it's added so that it's always for the next 10 years. And this links with the reserve fund, where we get the owners to pay a reserve fund levy. And the reason for this is to have proper planning of maintenance and also to try and get rid of special levies.
All right, is that it, Karine?
That's it.
All right, everybody. So thank you. I've just got one last question, Karine, that we haven't answered. It reads as follows. If an owner has an exclusive use area as a real rights registered on the plans, if they sell their primary section, their flat, can they still keep the exclusive use area registered in the plans?
No, you cannot. You cannot have exclusive use rights if you don't own a section in the scheme. So
Okay.
unless you sell it and transfer it together with your section, it will automatically cede back to the body corporate.
Okay, excellent, thank you. All right, so we are over time. If anyone needs to leave, they're very welcome. Otherwise, we will just work through the last question here. Adele, special levies continuously raised through resolutions for aspects that should be on the maintenance plan. What are your comments around that?
So that's why we've got the 10-year maintenance plan. We need to plan. So if there was a slide that Karine mentioned that if there was maintenance which was unbudgeted for, that we can raise special levies, but that's why the 10-year maintenance plan is there. So we can, you know, provide for those maintenance to be done. But special levies can be raised for unbudgeted items.
Okay.
Unplanned. Karine, I think that's the word they use.
Yeah, unforeseen, unplanned. If it can
Unplanned.
wait for the budget, yeah, if it can wait for the budget, it has to wait for the budget. But if it's an emergency and it's unplanned and unforeseen and unbudgeted, then it can be, then you can raise a special levy.
Okay. I've written my email address here, andrews@trafalgar.co.za. If anyone would like a copy of the presentation, if anyone would like the YouTube link of the recorded webinar, you're very welcome. I'll send that to you. You're welcome to refer it to colleagues, to other caretakers, to anyone that you think would find value in this commentary. We'd like to look forward to your attendance next Tuesday at 4 o'clock to cover the important topic of HR and HR management at Bodies Corporate, particularly referring to body corporate staff, many of which you would be involved with managing. You are welcome to invite any other participants to join. You can email me as well. I can send out the registration link so anyone can join for any of the modules. You know, we went through this reasonably quickly, but I think you'll find that we'll cover a lot of these same topics at the next modules. So we will get a chance to review and recap and repeat some of these important topics. And I think that will give a very good opportunity to answer further questions or to reinforce some of these important concepts. But it is very important that the better you understand these legal concepts and definitions, I think the better you will be able to address queries, deal with problems, respond to owners, and, you know, really solve problems in the correct way. So I'm just having a look here. Nothing in particular. I've got a few email addresses that I'll send the presentation to you. And I think we'll close on that basis. So thanks very much for everyone participating. We look forward to seeing you next Tuesday afternoon at 4 o'clock.
Yeah,
All
sorry,
right,
Andrew, if you can just post the questionnaire survey for us as well, that will, please, if you...
Okay, yeah, good. So sorry, there will be a survey which will pop up as we close the webinar. So if you wouldn't mind, please just completing the survey. It will take you less than a minute, and it will just help us to track if there are any improvements we can incorporate. We will try and address your recommendations, and it will just keep us in touch with, you know, addressing your requirements as best we can. So please do complete the survey, and it should pop up as I complete the webinar. So thank you, everybody. Good afternoon, and thanks to the panelists. Thank you, Karine. Thanks, Adele. Okay.
Thanks. Bye.